Is this causing the consumers to pay more than they would otherwise pay?
Hey everyone, it's Jonathan Lawless.
And I'm Jeremy Potter. Welcome to Housing Insiders. This is the podcast for founders, builders, lenders, and regulators.
Yeah, and everyone that believes everyone should be well housed, as we usually say. We wanted to start with, I guess I have to sort of say, the end of the last episode, we both made our bets on the Super Bowl. I picked the Chiefs. Jeremy picked the Eagles, and without a doubt, Jeremy won that bet. So congrats, Jeremy, on picking the right winner of the Super Bowl. But outside of the game, which was incredibly boring to me, I wanted to ask you your thoughts on the Rocket ad, since you've obviously been a big part of that in the past.
I thought that when you pick one of the best sing-along songs, Country Roads, that there is, you're in good shape to start with, because how many of us were watching the game with a group of people? I think a lot of people get together with a group. So that made a ton of sense. And then to kind of see that, you can own the American dream. You know how much time I've spent talking about how we need to frame, reframe, or rebrand the American dream. And so to see them pick up that mantle, it's not a comfortable spot for Rocket. Like, this is a new area for owning the home, owning the American dream. They're moving into a much different, I think, space relative to buying in 30 years of your life type of messaging. So I thought those two things were interesting. What did you think, John?
I mean, co-opting one of the most popular sing-along songs is pretty powerful. Although, like, now that everyone associates Country Roads with mortgages, I don't know if it'll be as popular in bars or football games. But
John, don't forget, we're going to have a move to West Virginia. Everybody's going to want to move to West Virginia. That's obviously the outcome here.
We've left West Virginia out of our previous conversations. Totally. The other thing I wanted to chat about. So we had talked in the past about Scott Turner's comments about the GSEs. Saying something along the lines of quarterbacking sort of housing reform. I think a lot of that was, at least in my view, kind of taken out of context. Obviously, HUD will have a role to play in GSE reform, but certainly not a leadership role. The subsequent comments that we heard, which I thought were really interesting, I wanted to kind of dig into it. I think there was kind of two aspects of that are interesting. First, so Besson came out and said something along the lines of like, certainly GSE reform is important, but we're not going to do anything that might cause mortgage rates to go up. And so I was kind of reading too much into that, of sort of like Treasury saying something along the lines of, Treasury's leading this effort, of course, because Treasury's the one has been running the show and it's sort of the ownership interest in the GSEs. But then I think this other part, which is maybe a caution or a recognition of a caution on GSE reform. I don't know. Did you kind of feel that there was more to that statement than meets the eye?
I really like that you said caution, because I do think it was an effort to calm down anyone who was claiming it would be too disruptive, right? So we saw a couple articles come out. How disruptive will GSE reform be? And there have been a lot of other spending cut types of executive orders that we talked about last episode that were claimed to be disruptive. And I think Besson was trying to address that. So I don't know that it actually was as deep a flag in the sand, so to speak, flag in the ground, whatever, to say that the rates, are the primary driver, but it was just something to say, everyone relax.
Yeah. It's kind of a funny comment in the light of the last few weeks of the administration, where it's sort of nobody relax, everyone don't go to work kind of thing, which we'll talk about in a second. But just out of curiosity, let's go back and forth real quick on Besson's general thought here, which is, if GSE reform is going to cause mortgage rates to go up, it kind of makes it a non-starter, which makes sense because a lot of this administration's promise is to lower costs for consumers. And so, where we're sitting today on the 11th, mortgage rates today are at 7%. 10-year treasuries are at about 4.5%, which kind of gives that spread between where mortgage rates are and where so the risk-free treasury is at 4.5%, a spread of about 2.5%. So the question is, what goes into that spread? Is it likely to be impacted by GSE reform? Let me just kind of take the major components and would love to get your quick thought. Will it be impacted? The biggest one by far is the just general spread of the MBS, sort of the risk-free mortgage pooled security, to the Treasury. And MBS looks like it's like roughly at 5. The 6% is trading at like 101. So like, let's call that a 5 3/4 or 5/8 kind of rate, 5.8% or something. So that's about 1.3% higher than where the risk-free Treasury rate is. GSE reform, up or down on that MBS spread?
So it would extend the spread.
Yeah,
The rates would go up,
The spread typically has sort of like the option adjusted component of mortgages can prepay, treasuries can't. So that's a part of it. But the rest of it is sort of how do investors view the riskiness of MBS? And so your point is sort of the Jim Parrott's recent argument is that you suddenly release the GSEs from conservatorship. They no longer have government backing if that's the way they're released and fully privatized. And suddenly that puts a lot of upward pressure on that particular spread.
Yeah, and I agree. I have a slightly different view, though, which is in order to attract private investment, to make the exit safer from a shareholder perspective, shareholders are going to want to see them extract some of the subsidy in order to return more value on the bonds as well, right? So my view was that it's going to be a move that rates will tick up slightly, almost to make the bonds more attractive, because that's what they need to do to ensure they get enough private capital interest to make the exit safer. I saw it as more, how do we attract private shareholders? And we're going to attract private shareholders by kind of right-sizing the rate sheet, for lack of a better way to put that.
Interesting. So adding even more to, I mean, maybe that's adding more to the GFI, but it's adding more, just generally more revenue and return for the shareholders, just period. Interesting. Okay. So I think our conclusion is that one's going up. I mean, it's really hard for that not to go up. There are ways to make it go down. That spread is abnormally high relative to history. And so maybe there is something that could be done, but without sort of addressing the risk or sort of potential price hikes in the other components, that's going to be hard.
How much do you believe in the potential sort of macro horse trading? Because I have heard one theory, which is in order to get out of tariffs targeted at your country could buy our bonds and we'll remove the tariff threat. That would be A. And then B, how much the White House continues to put pressure on our own bank to buy bonds back in order to lower rates. So would there be some sort of, hey, we're not going to make GSE reform disruptive to mortgage rates. We're still going to exit quickly, but we're going to do these other things to keep mortgage rates down. And that was the second part of the sentence that Bessent left out.
Yeah, really interesting. I mean, I'll answer the same way I answer every other question about what's likely to happen, which is who the fuck knows. But I mean, it's a very interesting lever to pull if you want that spread to go down. It's sort of force people or use the Fed to buy up bonds, and that could certainly tighten that. So if you're trying to figure out ways to do it, there is a mechanism to do that one. I guess the last one I was thinking about, and Jeremy, you and I have constantly talked about this, is FHFA has a lot of say over what origination costs look like. If rates might have to go up a little bit, could they offset that by saying, well, we've cut the cost of originating a loan in half? Is that a possibility?
I think it would take some creativity because there's always been mixed interpretations of what the GSEs can offer lenders and even directly to the primary market without becoming active in the primary market. And I've always taken a pretty innovative view that you can offer data and tools to the primary market without steering the primary market, without influencing the primary market. And so I do think that there is a tremendous amount of upfront data and upfront tools that the GSEs could offer, which would dramatically lower the cost of origination by moving a lot of the pain that we associate with the cost of a mortgage up front and still allowing people to shop. That is, I would say, a controversial view because a lot of people are very sensitive to this so-called bright line that the GSEs cannot play in the primary market in any way, shape, or form, even though you and I both know that a lot of the tools they give to lenders just get window dressing and put directly into the hands of consumers anyhow.
Yeah, that's a great comment. And I think, at the end of the day, based on kind of how we walk through it, starting at 4.5%, getting up to 7%, MBS spread is the biggest component likely to go up unless there's some significant, I think you're right, maybe sort of extra incentive to buy the bonds might be an offset to that. G fees, you could drop capital, you could try to do something else, but that's likely to go up. That's another 70 basis points. And then you got all the other servicing, other garbage things. So if you're looking for a win, as we've talked about before, my strong view is that the GSE should really focus on construction financing. And so that could be a big, hey, rates are going up over here a little bit, but homes have gotten so much cheaper because we've suddenly created a new pathway to financing supply. But then to your point, maybe getting really creative around how the mortgage industry generally works, what origination costs look like. I mean, that could be another sort of offset. So anyway, Treasury comment at the end of the day is, I think, a pretty straightforward one. Like, we're not going to do GSE reform. It's going to be totally disruptive and raise mortgage rates, and we're not going to get anything for it. Like, GSE reform is going to have to come with some wins. I think we've outlined a few interesting places where that could come from, but not an easy task. I'll leave it at that. Last topic, also crazy news, and I know we'll talk to our guest about this, but CFPB just doesn't exist. It's closed down. Nobody's going to work. Jeremy, I think you actually saw the email from the new director.
So 8:30 a.m. on Monday, the email went out, and it basically said, no work-related tasks without explicit approval. Email this email address, and you can get explicit approval. Otherwise, do not do work for this week at least. And I think the headline became the CFPB shut down. There have been other federal agencies like USAID that they are now being compared to. You saw a lot of that. CFPB is being compared to USAID in the media, especially in the housing press. But I think ultimately that email was, don't do work. And then, John, I think the question becomes, what is a work task? Does that literally mean I have the week off, or like, what? Do I check my email? No.
Can I read Housing Wire today?
Yeah. Hopefully you'll still listen to Housing Insiders. We're not work.
Yes, we are definitely not work. Well, I mean, it's pretty incredible. I mean, maybe we should come up with something fun for CFPB employees to do for the next couple of weeks while they're furloughed. It's really, I mean, as we know, the CFPB can't really go away. It's created by legislation, but it also, the funding isn't technically supposed to be there. So they really technically don't have the money to do anything. So they shouldn't be able to pay employees or whatever based on the way it's constructed. But it's just a very odd point. And it's just going to be interesting to see how, current investigations that are in flight, like, what are they done? Are they going to be dropped? I mean, it's really something else.
Agreed. And I think one of the reactions from a lot of people who are regulated by the CFPB was, what am I supposed to do now? My response was like, I found that to be kind of an odd question a little bit, because I was like, don't change anything. Like, I don't understand why this, if you are a regulated entity, would change what you're doing day to day. Sure, you have to watch it. You have to understand who regulates you, how, and what the risks are for your business, especially long term. But in the short term, are you going to start doing something now that you weren't doing yesterday? Are you going to start ripping off consumers today because you weren't yesterday? That seems preposterous to me. So, it's definitely dramatic. It's something to watch, but I don't think for a regulated entity, it changes anything, really.
Well, I guess I would suggest, given that I'm in a position of sort of being a real estate broker, is like, now is the time to buy single malt scotch for your best real estate partners. So go forth.
All right. So, maybe, John, that's a great question for our guest today. Can you buy single malt scotch for your best partner or not?
Well, okay. Yeah, let's move on to the guest. Today we're talking about a regulation, which is really fun. It's going to be wonky for a lot of people, but for anyone out there who listens to Housing Insiders, it's a regulation that you all know extremely well.
Yeah, RESPA. Those in the industry will know Trip Riley. He's a partner at Saul, Ewing, and he is the chair of the Consumer Financial Services Litigation Group. And he's based in Princeton, New Jersey. And he's represented and defended clients on RESPA violations, RESPA litigation. So we have a lot of questions for him. Trip, thanks for joining us.
Well, thanks, Jeremy. It's awesome to be here with you guys.
Yeah, Trip, super nice to meet you. Glad we're talking about this topic. It is super relevant to a lot of the work that I do, and I've often had a lot of questions. So I'm excited to kind of dive into RESPA. Usually acronyms that I dislike are 4-letter words, but this is a 5-letter word, which I think maybe makes it a little 25% worse. But in any case, I want to start with just asking, like, a lot of these laws kind of evolve over time to sort of become more than they were originally intended. I mean, probably all of them. Jeremy and Trip, you guys both know this well, but can you give me just like a lesson of like why RESPA exists? Like, where did it come from? What was its original intention?
Yeah, when you go all the way back, it goes back to the 70s, John, where real estate relationships, real estate referral networks, real estate transactions were highly localized. And it was not consistent across almost any market, any state, certainly not at the federal level, of what were you paying for what services to who. And between real estate agents, appraisers, title companies, and mortgage lenders, there were a lot of very cozy relationships where it wasn't clear which fees applied to which services and who was collecting what, but you just kept paying it because that's how you got a home in your community. And I have always heard a myth that one of the title agents was one of the Congress people who helped draft RESPA to try to bring some certainty and clarity, because a lot of what we're going to talk about today is one piece of RESPA where the fees, referral relationships, kickbacks, and partnerships created just a closed circuit of, if you scratch my back, I'll scratch yours when it came to giving customers and charging fees. So RESPA is really meant to be a regulation that clarifies and discloses fees, predominantly fees, and that's throughout the entire transaction. So originating a mortgage loan, any kind of relationship involved in the settlement services, the escrow accounts and servicing, and a whole bunch of documentation and disclosure and mortgage servicing. Of those areas, the one we want to talk about the most is the one that gets the most attention. The good faith estimate and the mortgage servicing escrow analysis doesn't get nearly the attention that the kickback provision and the unearned fees and the affiliated business relationships section get. So when you hear us talk about RESPA today, it's going to be almost exclusively Section 8, which is the section that governs all the relationships and the money flow between those relationships in a residential real estate transaction, even though this law purports to do all of these other things around disclosure and fees. It's really Section 8 that we're going to talk about.
And Jeremy, your comment regarding a closed loop, that's one side of the coin. The other side of that is transparency on fees that boils down to, is that closed loop causing the consumer to incur greater fees than they otherwise would? Because if you're paying for a referral, then the way to zero sum that out is to increase the fees to consumers. And so I think that when RESPA was passed, and when it was certainly when it was being sort of almost negotiated in Congress, it was the notion that, look, we want to have one real competition. And then the way they pushed it through was to say, because if we don't, the consumer, its costs are increasing. They're being stuck with hidden fees and hidden increases to fees. And that's really what put this over the goal line for Congress, is they wanted to protect consumers from having that increased fees.
It's starting to make sense to me. I'm trying to think of what the villains in this situation would look like. So let me make sure I kind of have this right. So if I'm a real estate agent, and Tripp, you're a mortgage lender, and Jeremy, you're a title agent, the closed loop is the three of us are in cahoots. So anytime one of us gets a lead, I'm always going to recommend you guys to the consumer, sort of push them in that direction. And as a result, Tripp, you're going to take me out to dinner once a week, and you're going to pay me $1,000 for every lead. And Jeremy, you're going to do the same. So is the idea basically that we kind of create this, we're in cahoots. The consumer doesn't know better because they don't really know that they should be shopping for these services. And we kind of charge them a lot of fees just because we can, but also because you guys are paying me referral fees. Is that sort of that's what's kind of being villainized here?
Yeah. It's not so much. Yes, they focused on lunches and trips and those things, but the real focus is in that scenario you just gave. I'm paying you under the table in a brown bag, or I'm just sending you a check. But I don't want to incur that cost. So I will increase the application fee. I will increase the appraisal fee. I'll put you into a loan program that has a higher interest rate, so that if I'm a broker and I'm selling it off to a lender, I'm realizing fees or additional income. And so that's the primary. And you also have to remember, though, that there are, and we'll get into it, I know, but there are exceptions to the notion that you cannot pay you cannot receive for those type of warm handoff referrals. The lender fee to a broker, that's accepted. The real estate brokerage referral to a licensed real estate brokerage in in another location, or who has a specialty in a specific type of property, let's say it's farmland or something, that's accepted. And there are a few others. And then we get down to an understanding that three of us as settlement services can provide each other with services. It might be some administrative services. It might be the marketing services agreement that everyone hears about. And as long as real services are being provided and they're being paid for at fair market value, then those have been upheld as being permissible under 8C2 of RESPA. And then I know we'll talk about the affiliated business, and that's an exception where the distributions from a company that's owned by settlement services who can refer into that business can get that distribution without it being viewed as a kickback or a referral fee.
Yeah, so we can get right into it, John. The idea is we want to create these protections that Tripp just discussed so that there is, transparency, shopping, and we really understand at least where all these fees are going. So then we have to create these exceptions when the fees are actually going to something real, something bona fide. So if you are in any kind of industry, real estate especially, you're going to have some activities where we overlap. So, this industry likes to pretend that real estate, mortgage, and title are three separate professional industries. I get it. I understand why. We have separate conferences, we have separate licenses, we have separate technology. But increasingly, we're not separate. And so these exceptions have to take into account when there's overlap, because there is, and when there are bona fide business development and marketing activities between us, because we do work well together and we are repeat players in the same community. So it's a really complicated problem when you try to create clarity in an industry where there is a complete overlap in the chain of the transaction among these professions, these activities.
So, so what you're describing, Jeremy, and let me try. So I actually sort of have a more fundamental issue with this, but let me just sort of say that the bona fide kind of exception process that you're talking about. So let's say I, as a real estate broker, have a title agent that I want to work with. And in this case, like, I do something like help schedule the closing or help fill out some forms that the title agent might traditionally have filled out. In that case, there's kind of overlap. Like, in other words, I'm actually providing a service to the settlement agent for the title company. And as a result, there's, maybe I should get paid for doing some of the administrative work for the title. That's the kind of exception that you're talking about with the overlap. Is that a bad example, or are there other more obvious examples?
No, I mean, I think I'm not even necessarily thinking about quantifiable work in that way that is resulting in the closing. I was even saying we all three want to attend an open house and we want to conduct a home buyer education course together, and we want to visit the local high school or the local college or the local Kiwanis club and all talk about the transaction together. We want to then go even a step further and take your listing and put all of us on it. We're not directing at that point. We're not referring business. We're just posting a flyer at the local post office or on the local digital the digital bulletin board or something. And it has all of us on there. Like, when you come look at this house, you should do business with all of us. Very different than working in cahoots. But how do you know? How do you know the difference between us marketing ourselves as a team or working in cahoots? It's very difficult to tell.
In the last year or so, there has been a push by people who really don't want to understand that relationship. And they want to argue that what Jeremy just talked about at the finite point of just being together, whether it's at an event or it's on a marketing piece, is that's steering. Somehow that's steering consumers, and that's bad. It's terrible. Is it steering? Well, steering has both a positive and a negative connotation. Steering is fine if the consumer understands everyone's position and relationships steering is bad when that's concealed from them. Why am I telling you to use Jeremy? Why are we working together? And so that comes down to transparency. And we have people again today who are challenging. They say there's no way that any transparency is going to affect the steering because, say, a real estate agent has this fiduciary relationship with their consumer, and no amount of disclosure is going to, in their view, eradicate a bad action by someone who has a fiduciary relationship. In fact, they're saying they shouldn't be telling anybody, any of their consumers, who to use just because of their relationship. And I think that really doesn't take into account relationships that consumers have with their real estate agent or their title agent or their mortgage broker. I mean, those are relationships of trust, yes, but also of assistance. And so the notion that these people under RESPA somehow, or under the CFPA, which is the Consumer Financial Protection Act, or state consumer protections, can't refer, can't give advice. That's what Jeremy is talking about when he says we're in an ecosystem together. And if anyone thinks it's a good idea to break that ecosystem up and make them completely disparate, doesn't understand the home buying process.
What I was going to say, sort of my fundamental issue with this is that it strikes me that the highest cost of any settlement service provider is customer acquisition costs. Like, they're spending the most amount of money in their sort of stack of money spent. Talk about a loan officer, right? A loan officer is spending a ton of time and energy and money to get a lead. If that loan officer were able to just be handed a lead from, say, a real estate broker who's already paid to get that lead, in some ways, the loan officer should be able to charge less. Like, I'm doing less work, therefore I can cut my costs, or slot in anyone in the settlement service provider stack. So in some ways, this kind of, the bad way of saying in cahoots, but maybe in partnership, if that partnership is done well, it should be driving down costs for the consumers, because not every single element of the settlement service chain is having to spend billions of dollars every year to market to be able to get leads. So that's kind of my fundamental issue, which is like, this idea of lead referrals is one that should cut costs out. Whereas I see the point you guys are making, which is there is a way in which it could increase costs, in which, like, if you were truly bad actors and you were truly not giving people options, you're truly not being transparent, yes, I could refer somebody to Tripp because I know Tripp is I'm gonna pay him a bunch of money and he's gonna double charge. Anyway, there could be a bad version of that, but you just don't know. And Tripp, what I'm hearing you say is, like, given that you don't know, any kind of referral or any sort of helpful suggestion from somebody who's just, hey, look, I know Jeremy's a great title agent or a great inspector, whatever. He's going to give you a great discount if you use him through me. Even if I do something like that, even that's 100% true, even if the customer signs a bunch of paperwork saying, I recognize that you're giving me to Jeremy because he's giving me a deal and I know this and I know I can check anybody else. Like, even if that happens, there's still likelihood for a lawsuit.
What I would say, let me back up again, is that there are a group of individuals in this industry, or on the peripheral of the industry, who say that can't happen because it causes steering, the bad type of steering, the unknowing steering. And by the way, even if the consumer is aware, it's somehow a breach of whether it's agent, let's just use real estate agent as an example, they have this fiduciary relationship with the consumer. And the minute they refer somebody, it's steering, and they've breached the fiduciary duty they have, the duty of trust, the duty of loyalty. I completely disagree with that. That is a misunderstanding of the relationship. And let me just go back to your question about cutting costs. And this leads, I think, hopefully into a discussion of 8C4. Okay, you talked about all that marketing and acquisition costs. Okay, so how does an affiliated business arrangement help cut down those costs? Okay, you have a real estate agent or brokerage that is spending a ton of marketing dollars, training and seminars and all the other stuff to get business. And so is a title agency, right? They're doing the same thing, just tons and tons of money. They set up an affiliated business where you have real estate brokerage owner, a few real estate agents, and the owner of the title agency, and they own a title agency together. And most of their business will be referred by the real estate company and the investors to that company. So what does that mean? That title company, assuming it's totally legit, it's RESPA compliant, doesn't have to do as much marketing. So what can they do? Well, where those fees are, they can dictate their fees. In some states, obviously, you can't do that, and there's a tariff or filed rates or so forth. But in where they could reduce those fees, they can, because they're not charging as much, they're not paying as much for marketing. And that's what, and then on the people who hate them say, oh, but they have captured this business. Well, the title company still has to make the argument why the consumer should use them. The real estate agent who owns some interest has to make, after disclosing they have an ownership, has to make the argument why they should be used. And as they're saying, it's more efficient, I get to interact, there's less fees, there's nothing. And that's why that exception exists, because all the studies have shown, okay, contrary to people who say they don't, that all the study shows that working through an affiliated business reduces consumer fees, increases transparency, increases the ability to interact with all the different components, mortgage, title, and brokerage have, or any others. So that's why that exception exists, because they recognize that it provides a benefit to the consumer.
Can you say what the exception is specifically? You called it HC4, so I assume that's some sort of subsection, subtitle code. There's an exception for affiliated business arrangements. How does the exception work exactly?
All right, so let's start back at 8A. And 8A says, no person can give or receive a thing of value for the referral of settlement services. Okay, so in that instance, if I'm a real estate broker and I refer to a title company and I get paid for that, I get money, I get a trip. The more I give, more referrals, I go to Costa Rica or what have you. That's a referral fee or kickback that's prohibited. 8C4 says that settlement service providers can form a settlement service company, and the distribution from that company to the owners who are referring customers to that, the profit distributions will not be treated as a referral fee, because otherwise it could be, right? Under 8A,
it's a thing of value.
I'm referring to title company that I have an ownership interest in, and I am receiving a benefit from that referral through the profit distributions. Anyone could make the argument, a fifth grader could make an argument that that's a referral fee, it's a kickback that's prohibited under 8A. So Congress said, but in these instances, if three things are done, then that distribution, that profit distribution, will not be treated as a referral fee under 8A, a prohibited referral fee. What are those three things? One, the referring owner needs to provide a disclosure, and the joint venture affiliated business needs to make sure they have a policy and procedure that disclosure is in the file, it's being collected. The second is that the referring party, who's the owner, also an owner, can't require their customer to use the affiliated business. So if it was a real estate agent, they can't say, hey, Sally, I'll show you houses, but you have to promise to use XYZ title agency. And the third is that the profit distributions to the owners only reflect their ownership interest, not the amount of referrals they have or the number of captured customers they have, or the amount of revenue that's generated from their referrals. Let's just break it down. There's three investors, and the one investor is a real estate agent, and 80% of the business is coming through her referrals. And so she gets 80% of the profits, even though she only owns a third of the company. I mean, that would be prohibited.
So I'm going to take the bait because Tripp said a magic phrase that I think will illuminate even more complexity here. And that is, John, it's basically saying if you go into business together for real, if you go into a real business ownership structure together, we'll take the RESPA rules away from sort of that high level profit distribution, that Tripp mentioned. But Tripp, you also said joint venture. So what happens in this industry is then joint venture becomes shorthand for like, oh, let's set up a joint venture because then we don't have RESPA, right? Question mark is like what happens in these conversations. Can you walk us through a little bit of some of the best practices around this? And I guess my direct question is, as a hypothetical title agent in this relationship on this, can I be in multiple joint ventures? Can I own a third of 37 different relationships with 37 different real estate brokers?
So let's hit the first sort of comment you have, and let's just be clear. An affiliated business or a joint venture, when you set them up, the purpose is in fact to realize ancillary business as a result of your referrals. It's almost as if people want to treat affiliated businesses as something other than or pretend it's not what it is. It is, no question, an exception to 8A, right? It's so that investors can realize a benefit from their referral that they would not otherwise be able to under 8A. Don't run away from that. It is an exception. Okay. So yes, you sort of said like, oh, if I set up an affiliated business, then I'm not controlled by RESPA, like all that. That's not the approach to take. The approach and the way to think about an affiliated or joint venture is to say, I want to benefit from my referrals to this title agency. Can I do that? And the answer is, if you're an owner, and only to the extent of your ownership interest. And two, you must disclose to those who you are referring that you have an ownership interest. And you actually have to, if you have more than 1%, you have to identify that in the disclosure. You might have a direct ownership. You may invest with a bunch of people through an LLC. You still have to disclose you have an indirect ownership interest. You have to, if you're referring on behalf of an owner, right? You need to disclose that you work for. You have to disclose that your owner, right, the owner of your company has an interest, right? You have to do that, and then of course you can't require the use. So you don't run away. Don't say, "Oh, I'm really not doing anything. RESPA doesn't apply because I have this affiliated business." It applies because it wants to give you. That's the purpose, is to give you that ability to benefit from your referrals in a transparent world, in a transparent, disclosed way. Okay, that's number one, right? Because people want to, and when people who don't like affiliated businesses say it's just a way for them, it's just a pass through. Yeah, it is. But the statute allows for it. The regs allow for it. And every agency that has touched it, HUD to CFPB, allows it as long as the 3 statutory requirements are met and the structure of the joint venture is somewhat compliant with the HUD 10-part test, which we can talk about. Though that's not the law, that's not law, right? But the bottom line is that you do and you can benefit from referrals by being an owner, being transparent about that. There's just no way that becomes illegal. It's an exception.
It's a feature, not a bug. I love hearing you say that. I'm actually getting really excited to talk about a reg, which I wasn't anticipating this morning. So I want to pause this for a quick break. And when we come back, I think there's a bunch of things to talk about, and especially in light of the fact that at least at the time we're recording this, the CFPB, nobody's going to the office. So it's certainly an interesting time, at least for the agency that from the federal perspective regulates HUD. So anyway, let's take a quick break and hear from our sponsors, and we'll be right back. This episode is brought to you by Bilt Rewards. Bilt is a rewards program, just like an airline program that is centered around your home and neighborhood. But instead of earning miles for flying, Bilt rewards you for paying rent, no matter how you pay. As a member, you can earn points at over 20,000 local restaurants, local merchants, and those points are now the most valuable rewards currency. You can use it to book travel, on Amazon, or even towards a down payment.
Bilt is revolutionizing housing. If you want to learn more, email John at lawless@biltrewards.com. Welcome back. We're talking with Trip Riley about RESPA, and we're deep within the Section 8 requirements and exceptions around a lot of the relationships and activities that go on in this industry. John, I think what you're hearing is one of these key aspects to this law. It was written at a time when these local relationships controlled a lot of what happens in a real estate closing. And now we have very sophisticated affiliated business arrangements. We have very sophisticated technology passing data and transparency back and forth within these relationships and within this market. And so now we have some interpretation of an older law that was written for a time when technology, speed, and really competitive advertising and competitive landscape was totally different, and we're trying to apply it. And as you've heard, a lot of our examples are what I would call kind of more old school examples of a real estate transaction. I think we have to think about what are the modern applications now when you're shopping online and you're getting your disclosures through text, and you're getting your disclosures when you're just able to jump on your laptop from your couch and shop. And so, you had mentioned sort of how this unlocks all these questions. We're deep inside the regulation, but it's a regulation that is written when you have greater shopping capability than ever before. You have greater disclosure capability than ever before. And so I'm really interested to hear how this evolves in a market that looks very different, and increasingly different.
It's no longer, well, I wouldn't say no longer, but there's a majority of business within the settlement services that's happening on a national basis or on your computer, right? So you're searching wherever you're searching. And it's not about going to your real estate agent and saying, hey, I'm looking for a house. Who do you recommend for his title and so forth? I'm looking on a site. It may be it's sort of a dual site. It has houses for sale. It has this, it has that. And then there's all these lists of possible vendors. And a lot of times, as we talked about earlier in the session, is that people are paying marketing for that, right? They're paying to be on these sites. They're paying to be at a particular location on these sites. And the CFPB in the past has said that type of payment could be a violation of 8A because the site could be considered to being referring all those eyeballs, right? And they're getting paid for it. And remember, RESPA it's any person. So literally, if I referred business to a real estate agent or a title agent and I got paid for it, I'd violate RESPA and they'd violate RESPA. And I'm just a lowly lawyer. I'm not even in the industry on an operational basis. So you apply that to these sites where all this marketing is going forward. And so where somebody could make the argument, hey, you're paying XYZ landing page $1,000 a month to be the first title agency that shows up on their page. Or you're paying a large real estate brokerage company, a multi-state that has their own affiliated mortgage company, title company, insurance company, home warranty company. And of course, they want the consumers to use them. And so the interplay with the transformative nature of real estate industry and marketing and so forth that you're talking about, Jeremy, really opens the door to interpretation. And that's really what we're going to be I think we're going to be facing with, is that putting aside that the CFPB is, taking a nap right now, who's going to step up? And I think that we have seen attorney generals, state attorney generals, thinking that they can fill the void, not only from a standard enforcement perspective, but also to add what they think is needed, meat on the bones of interpreting what a referral is. What is a thing of value? How do we define that in any specific joint venture? I'll give you an example. And this isn't even a joint venture. This is a real estate agent has a relationship with a mortgage company. And the mortgage company says to the real estate agent, listen, tell your consumers to use us and we'll give half price on the application fee. So that goes to the consumer. That's awesome. But if I'm the real estate agent, is that a thing of value to me? Because I can go out and market myself as having a relationship that will provide the consumer with half price on the application fee? No one else can do that. I'm not saying they can't do it. I'm just saying the mortgage company might, let's say they've just started and they offer it to me and no one else in my market gets it. Is that a thing of value?
Is exclusivity in marketing claims a thing of value is one of those questions where, at least from my perspective, Trip, that's where you go down the rabbit hole, right? Now you're trying to say that like these notional things, this idea that I have a marketing claim, I have a sentence that I can say in my marketing that no one else can say, well, that has some value to it. We just don't know what it is and we can't measure it, but it must have some value because you can now market differently. And even though the benefit's going to the consumer, we're going to try to put value on that so that we can tell you not to do that. That to me is the point where we're way down the rabbit hole. But
that's where the action is right now. That's where, whether you're a state AG or you're those who are anti-affiliated businesses or anti-marketing services agreement or anti putting stuff on a web page and you're paying to be the first, the second, the third, or what have you, or where are those clicks going once the consumer touches the second one, and is that lead being sold to multiple people and things of that nature? That is not either the CFPBs, the FTCs, the OCC, or the state AG's job. They don't get to create. In my view, they don't get to create those definitions and those interpretations. But that's where the flexibility is. Both let me do all these things and it's not a thing of value, and those who say it's a thing of value. And I think really what it comes down to is, and this is what RESPA is all about. This is what we started with. Is this causing the consumers to pay more than they would otherwise pay? That's the first question that any regulator, any enforcement attorney should say. Is this causing a problem? I'm not saying you get rid of 8A and say, well, a thing of value is only a problem if the consumer is paying more, because there are other issues to be addressed. But it should be the fundamental and paramount issue when determining, should I move forward with an investigation? Should I really push this, as a government enforcement lawyer?
Yeah, it seems like the question they're asking is not, is this going to cause a problem for the consumers, but could this? And if somebody has a good imagination, there's always a way that it could, even though that's not the intent or the interpretation. And I think what's particularly scary, thinking about this sort of amorphous interpretation that state AGs might bring to the case, and sort of what Jeremy started with, which is, the world's changed. There's so many non-settlement service providing companies that have a digital relationship with a consumer, that have a true opportunity to provide the consumer with advantageous direction on where to get a mortgage, where to get title, where to get a real estate broker, so on and so forth. They can't because they just are immediately going to run into a RESPA violation, even if the thing that they're getting in return is, as you said, sort of exclusive marketing or something just as hard to interpret as that. There's been a lot of instances where I've seen companies like Lending Trees or other things where it's like, I'm going to give you access to a bunch of potential places to go. And that seems to have fizzled out or doesn't work. Like, I've heard marketing service agreements is another term that I've heard thrown around in this context, MSAs, as something that particularly doesn't work or could work. Or anyway, I'm just very curious about what's the state of, I've got a digital relationship with somebody. I want to make it easier for them to get access to real estate settlement services. I want to figure out how to monetize that. Where is that right now? Like, are people doing that? Are people not doing that? Are they scared? Have they stopped?
I don't think that they're scared. I think they're looking for ways that make sense. And when they come to me, I like to use my stoplight example, right? Or my stoplight counseling: red, yellow, green. I'm rarely in the red. Well, I've seen the red. I'm rarely seeing like bright green. Like, everyone wants to figure, they know what they can do. It's a question of what can they get away with, and I don't even like that term. It's just pushing the envelope. But there are any number of people who have a digital relationship with consumers, whether it's active, or it's sort of static at a particular time, and they're trying to figure out how to monetize that relationship, but at the same time give consumers the information that they want. And I think that just an example off the top of my head is a home builder, right? Or someone who has a bunch of, like, a commercial, like a rental platform, right? So they've got all these people and they have a relationship with them. And how do they get them, when those consumers want to look for homes, how do they get to the right people? But at the same time, they have a platform, they're spending money on it, they're providing services, they should get paid for it. So what can they do? And that's when they come to lawyers like myself and they say, I have these relationships and I think they touch RESPA. Maybe they do half the time. How do we address that? I have a particular client right now who part of their transactions would be covered by RESPA, and like 1/3 of them and 2/3 of them, same consumer, wouldn't be, depending on when they touch that consumer. Is it part of a finance transaction, or is it after a finance transaction? Or is it not even after, it just has nothing to do with them buying a house? And they have to figure out how to put together a relationship with the consumer where part of it has, they have the concern with RESPA and others they don't. That's the hard part now, is to try to figure out how to interact with consumers in this digital world where maybe only a sliver of what you're doing hits RESPA.
Super fascinating. I mean, I think of, platforms like NerdWallet or others, like they even have a financial bent to them potentially. And to your point, my guess is 90% of what NerdWallet is probably generating leads for is not RESPA. It doesn't cover RESPA, but the other 10% is. And then if it is covered by RESPA, it's sort of like, do I have to create joint ventures with every aspect of the settlement service, or do I take another route? And it just, it's a really interesting situation that the industry's in. Very bizarre.
And the really hardest question is, what is a referral? Right. And so you could be providing them sort of just general information. I'm just sending it out to you. Yeah. You click a little button that says, do you want information on mortgages and on title and so forth? You say yes. And you send out whoever's in your network. Is that a referral, or is that just giving information? Right. And to me, it's always been, a referral is always, you sort of think of like a warm handoff. To me, that's the referral, where maybe that happens. And then the consumer gets back to me and says, well, okay, you sent me 10 mortgage companies. Which one do you really like? And they're willing to say, right? Rather than saying, oh, I can't tell you, because they want to have that relationship. They say, well, this one and this one, consumers have come back and said they're awesome. So we enjoy working with them. We enjoy giving their information. You should call them. There's the referral.
And so it sounds like, I think two things I'm hearing. One, I think it'd be good for, our audience to hear the best way to handle this, it sounds like, is to go directly at it. Hey, this is what we're trying to do. This is how we are not trying to rip anybody off. We're not trying to hide any relationships, hide any disclosures. We're simply trying to do, and then whatever it is that you're trying to do, and set up everything accordingly so that when you do have someone who's curious, whether that's an investigator, regulator, somebody looking into it, you're not scrambling around and trying to explain it some other way, or in this guise of, to John's point, everybody with a creative mind could find a problem here. Instead, it's actually better to just upfront say, we're a marketplace for information, or we're a marketplace for shopping, or we have these relationships, and then address it that way. And it also sounds like, so that's one of my takeaways, but Tripp and Jonathan, it sounds like the second thing is, it should actually get easier in a digital world. So we're finding that it's more confusing because of how this regulation gets applied. But the reality is, you have all kinds of audit trails and tracking now, when in the old world, everything was done through a conversation in a car, or a conversation in an open house, or a conversation in the community. And now we actually have a path to be able to show, here's the screenshot they saw, here's the disclosure they saw, here's the button they clicked on. Oh, and by the way, it was 11 o'clock at night. Nobody was even around. They were just simply shopping on their own. And I think that should really go to support, Jonathan, what you were asking about, which is like, how do you do this? How do you navigate this crazy regulation? Well, this is how. Is you actually tell the story proactively, confidently. We're not doing anything wrong here. We're literally trying to get people the resources they need and get them a better deal. And if you are actually doing those things, it'll be true. It'll show through.
Yeah, it will. It will. And that's what I tell my clients is, don't try to hide behind what you think is compliance. Like, put your compliance right up front. On a digital platform, it's things like, this is not a referral, right? If you want a referral, we can put you in touch with blank, right? So anybody looking at that will see this is what the consumer saw, right? And then if they get a referral, they get a disclosure and what's being paid for. And that's one thing we didn't sort of talk about, which is also, what's the compensation? So if the relationship is supposed to be leads, not warm referrals, then you better be paying what is market rate for for leads rather than referrals. And we know the difference between a lead and a referral payment. The referral payment is always higher than the lead payment.
It should be. Yeah, I mean, the thing I'm struggling with, and we probably don't have time to get into all sort of the rules and requirements around compensation, is like, despite your best intentions, it doesn't, because there's so much gray area, it doesn't protect you 100%, right? So there's always another director who could take over the CFPB, or a state AG who might just have a different interpretation and, at least cause you pain in the sense that you have to defend yourself from some claim. That's one issue. And then the second issue is like, the most valuable thing is leads in this business, and a solid lead. And it just feels like the way this is structured doesn't allow you to really be compensated directly for that sort of work, or at least pass along or share in the savings it creates downstream, which at least is what I kind of often see. And so, and maybe agree with me or maybe don't. I guess it's sort of besides the point. From the question I want to ask, which is, I know the MBA has raised some concerns around RESPA. They put together a thought piece on this. So what I'm actually curious about is, if there were to be clarification on what a digital lead is, if there was going to be change to RESPA, how does that actually need to happen? Is that something that has to be congressional? Could the CFPB rewrite it or reinterpret it and publish an interpretation? Like, let's take the MBA reforms. Like, what has to happen in order for RESPA to be changed?
No, I was going to say, I believe it's congressional change to RESPA. When we talk about the language of 8A and the language of 8C4, you can make interpretations, guidance that does exist at the agency level, but the actual language of those needs to be changed by Congress. And then I know there's all the interpretation, and, Tripp, you can tell us like who interprets it and who is able to make those interpretations. But I believe that that's what MBA would be asking for, to have Congress make that red line.
Like any statute, RESPA is bare bones. It gives you what is permitted, what's not permitted, what's an exception, and then some very bare bones, like with Section 8C4, those 3 requirements. So if those are going to be changed or they're going to be expanded, they're going to be, the definitions are going to be either enlarged or redefined and so forth. The first place you'd like that to be is the statute, because the CFPB could always issue regs that define those terms. But given the recent Supreme Court decisions regarding what an agency can and cannot do in terms of, interpreting the statute through its regulations, I'd rather see it, as Jeremy, I'm sure, does, at the statutory level, right? Because that's Congress saying, here's what our view is, here's what we want, very clearly. And then all it would take was the enforcing agencies to follow that to the letter of the law, rather than trying to provide interpretation. And that's what we've seen with the CFPB and other agencies, but most like the CFPB, is regulation by enforcement. And what that really is, looking at the statute, and it's everything we've been talking about, and saying, well, I think a thing of value is this. And we're like, well, where in the statute does it say that? Well, our interpretation falls within the definition. Well, where's the definition? Okay, it's in the reg, but that's not very, helpful either. So I'd like to see if there's going to be changes that are needed. I don't particularly think there needs to be any changes. I think that the intent of the statute is very clear. What it was supposed to protect is very clear. I don't want to see amendments. I want to see what we're just talking about, which is filling in a definitional section, filling in, for example, we have, instead of having it in Reg X, where it talks about disclosures not happening, and as long as that mistake was good faith, it just didn't happen. It was just basically negligence, but there was a policy and a procedure to make sure that those disclosures were done, and it wasn't intentional, then you can't get tagged for not giving those disclosures. Okay. But it would be really nice if that was in the statute and not in the reg, because then we would understand what Congress's intent was. That language was created by HUD back in the day, and fine. But again, that was 30 plus years ago. And the process of who now needs to give a disclosure is so much broader. Those who fall into that, who could fall into that, so much broader. And so it would probably be better to understand now in this digital world, what does it mean to make an honest mistake in giving a disclosure? Who needs to have the policies and procedures? Not just, is it just the affiliated business, or does it also have to be the referring party who has a policies and procedures? And that could all go into the statute.
It's amazing, and I thought that was super helpful. I wanted to end with just a question that you and I were talking about before, but just because for our audience it's a pretty important one, which one might feel the temptation, given that the CFPB, as of right now, has nobody going to the office. And the CFPB, of course, is the federal agency that enforces RESPA. What that does not mean for the industry is, hey, RESPA doesn't exist. Let's go forth and do the things that we had always wanted to do, but now that the CFPB is not there, we can actually do it. That's not true. And for a second, I want to make sure we make that clear to the audience why that's not true.
A couple of reasons it's not true. First, they have a 3-year statute of limitation on RESPA. So whoever takes over RESPA, whether CFPB somehow disappears, which Congress would have to repeal the statute, right? And that's not going to happen. A year from now, 2 years from now, 3 years from now, totally different situation. CFPB is back to active or whoever. And if you violated it a year and a half ago, you're going to be subject to a potential investigation and enforcement action. The other thing is that every state AG has enforcement authority under RESPA. Well, it's not under RESPA. It's under the Consumer Financial Protection Act, gives them authority to enforce RESPA. And so those AGs, it could be They're doing it on their own. They could get a referral from the departments of insurance and banking, the real estate commission. They could get it from consumers, and most likely they'll get it from competitors. And they're then free to start an investigation related to, 8A and 8B, or down the line, all the other exceptions.
Fantastic. Trip, first of all, thank you so much for joining us. I'll have to say, the question I get most often around the law is, do you know a good RESPA attorney? So Trip Riley at Saul Ewing, it's been incredibly insightful to chat with you. So thanks for joining us.
I really appreciate your time and your listeners' time.
Thank you, Trip.
That'll do it for this episode. We love hearing from you guys. Send us an email at podcast@thehousing insiders. If you like what you hear, please leave us a review or rating wherever you get your podcasts.
And subscribe and share so that we can keep making this podcast for you.